My name is Ron Drescher. I'm an attorney practicing in bankruptcy and commercial litigation in Maryland, Virginia, Delaware, and Pennsylvania. Now, why do we have these laws? What's the point of it? The point of the preference laws is that there's a presumption in the federal bankruptcy laws that during the 90 days before a bankruptcy case is filed, that debtor is insolvent. That means that there are more debts than there are assets to pay the creditors. So that means that some creditors are not going to be paid. So if some creditors are not going to be paid, that means the ones that were paid were preferred over the ones that are not paid. Congress says that's not fair. It's not fair to the creditor that didn't get paid that this other creditor did get paid. So at least theoretically, we're going to pull back the money from the creditor that did get paid and redistribute it. We're going to spread it around fairly, pro rata, based upon their claims, and give it proportionally to creditors. Now, that's what's supposed to happen. What typically does happen is that in a Chapter 11 or in a Chapter 7, there are large fees due to attorneys and accountants, and a creditors committee may have an attorney. And so sometimes there are unpaid expenses of maintaining and administering the bankruptcy. And those will get paid first from the money that comes in from these preference recoveries. So what does that end up meaning? What it ends up meaning is that the creditor who received the money in the 90 days before the bankruptcy does pay the money in. And that creditor ends up suffering just as much as the creditor that didn't get that payment in the 90 days. My name is Ron Drescher. I'm an attorney practicing in bankruptcy and commercial litigation. And if you have a question about maybe getting sued for a preference or anything else I've talked about, please pick up the phone and call me. I would love to hear from you.